Section 35, Secrecy Direction relating to inventions relevant for defense purposes. The Patents Act provides for certain provisions of secrecy, and when we say secrecy, we specifically refer to the ability of an invention as disclosed in a complete specification to be kept as a secret. In the context of patent law, when we say kept as a secret, we always understand that as its opposite, or we understand that by comparing with its opposite. Patent specifications are designed to be published, and they would eventually at some point in time they will be published and will be available to the public. Now, in many case laws on proving lack of inventive step or obviousness, what matters with regard to the prior art was whether it was made available to the public. Publication of an application or a granted patent makes the invention available to the public. The public can do many things with it, it can refer to it, it can work upon it, as long as it does not infringe upon the rights granted under section 48, the public at large is allowed to look at the invention. A secrecy provision, when there is a secrecy direction issued under the Act, the invention will not be published, it will not be granted, rather it will be kept in a secret mode, in the sense that it will be kept away from public scrutiny. Many countries have secrecy provisions, and they are all tuned towards national security and for defense purposes. If a country feels that certain inventions, if they are published or if they are put into the public domain by publishing the application or by granting the patent, then there could be an issue that could affect the security and the defense of the country. So, many countries have similar provisions. So, section 35 allows the controller, if he is of the opinion that the invention is relevant for defense purposes, then he may give directions prohibiting or restricting the publication of information about the invention. So, we already mentioned complete specifications are designed to be published. If you do not publish a complete specification, if you do not take a request for publication, they automatically get published after 18 months. So, there is no way you can keep a complete specification a secret, because they are designed to be published, and the fact that once when they are published, the matter disclosed in the complete specification would fall for public access. The central government and the controller are empowered to keep certain invention as secrets. Now, let us look at section 35. Section 35 states that where in respect of an application made before or after the commencement of this act for a patent, it appears to the controller. So, what matters is the opinion of the controller. So, we will get into details as when the controller forms this opinion. It appears to the controller that the invention is one of a class notified to him by the central government as relevant for defense purposes. So, we understand that the controller forms his opinion, which is based on a notification by the central government. So, the central government will make a notification on certain technologies or certain inventions being relevant for defense purposes, or whether otherwise the invention appears to him to be so relevant. So, one, if it is one of the notified classes, yes, or even otherwise if it is not in the notified classes, but the controller forms an opinion that this could be meant for defense purposes. For instance, if you look at night vision, night vision is something which came up as an invention that could be used in military purposes, but today there are various other equipments which have incorporated night vision. So, when the first time night vision would have been patented, there may not be a clear implication on what could be the reach or what could be the impact of such a technology on defense. So, the controller can either go by the notification issued by the central government, or the controller can form his own opinion. So, what does the controller do if he forms his opinion? He may give directions for prohibiting or restricting the publication of information with respect to the invention or the communication of such information. Now, this is what the controller can do. Controller can prohibit the publication of information with respect to the invention. So, he can prohibit the initial publication. So, the controller, from this we understand that the controller has to form his opinion on the invention before it gets published. So, assume a case where an application is filed, along with the application form 9 is filed. So, when form 9 is filed along with form 1 and 2, the application should get published immediately, because form 9 is a request for publication. So, assume a person files form 1 and 2 along with form 9, then the application will not wait for the 18-month period, it may get published immediately. Where does the controller form his opinion? Because this provision says the controller should form his opinion, and normally the controller will get to see an application after the application comes before him and he allots the application to an examiner. This is normally after the publication, after the 18-month period. But if an application comes along with form 9, which is a request for publication, then the application will have to be published immediately, depending on the number of pending applications. If there is a queue, then according to the queue, but the norm is when a request for publication is taken, it has to be published immediately. Now, if a person takes an application form 1 along with form 9, when does the controller exercise his discretion under section 35(1)? Because assuming that there are on an average there are close to 50,000 patent applications filed in India every year, the controller may have to go through and make a preliminary opinion before there is a request for publication. So, we understand that if a request for publication is filed, then the controller will have to exercise some kind of a scrutiny, a quick scrutiny before it is published, or if the 18-month period is available for it, any time before the 18-month period, because this call has to be taken by the controller before the publication. So, the act is really not very clear as to what time the controller will exercise this, when will he form his opinion, but we can understand that it has to be done for the secrecy provision to be effective, it has to be done before the publication. Now, let us see how it works. 35(2), where the controller gives such directions as are referred to in subsection 1, he shall give notice of the application and of the directions to the central government, and the central government shall, upon receipt of notice, consider whether the publication of the invention would be prejudicial to the defense of India, and if upon such consideration it appears to it that the publication of the invention would not so prejudice, give notice to the controller to that effect, who shall thereupon revoke the directions and notify the applicant accordingly. Now, this gives us one scenario where the controller feels that something is relevant for the defense purposes. He has to give notice to the central government. The controller first passes a direction saying that there shall not be any publication of the information. He passes that direction, which means the patent office will now not publish that patent application. The invention or details pertaining to the invention will not be published. Once he issues the direction, this is a sequence of events. The controller looks into the application. He is of the opinion, either by considering the notification issued by the central government is expected to give a notification listing out the things that are relevant for, or technologies that are relevant for defense purposes. He may rely on the notification and say something is relevant for defense purposes, or he may on his own opinion come to a conclusion something is relevant. When the controller forms his opinion, he will first issue a direction saying that secrecy direction is issued under 35(1). information should not be published. Once he does that, once he issues a secrecy direction, the next step will be to communicate that by way of a notice to the central government, because the controller is not the person who can take a call on whether something is relevant for defense purposes or not. He can at best make his preliminary opinion. Based on his preliminary opinion, he can issue a direction not to publish, and that is an internal affair within his office. He has to pass on, he has to give notice of the application and the direction that he has issued to the central government. The central government, upon receipt of the notice, shall consider whether publication of the invention will be prejudicial to the defense of India. So, the call on whether something will be prejudicial to the defense of India has to be taken by the central government and not by the controller. There may be some confusion with regard to who takes the call on secrecy. The direction of secrecy is issued by the controller. The controller issues the secrecy direction, but the decision whether something is prejudicial to the defense of India, that decision is taken by the central government. And what does the central government rely on? The central government relies on the application and the direction issued by the controller. Once the central government comes to the conclusion that publication of this particular invention will not be prejudicial to the defense of India, then the central government shall give notice. The first notice is given by the controller to the central government. Now, the central government shall give notice to the controller saying that this is not prejudicial. On receipt of the notice, the controller shall revoke the direction which he earlier issued and notify the applicant accordingly. When a secrecy direction is issued, nothing happens on an application. The application will not be published. There are provisions where the prosecution can happen, but the application is not published. But once a secrecy direction is revoked, and that is revoked by the controller upon a notice issued by the central government. So, there are two things: the issuing of the direction, secrecy direction, and revocation of the secrecy direction is done by the controller. Issuing the secrecy direction and revoking the secrecy direction is done by the controller, but the decision on whether a technology or an invention will be prejudicial to the defense of India is a call that the central government has to take. 35(3). Without prejudice to the provisions contained in subsection 1, where the central government is of the opinion that the invention in respect of which the controller has not given any direction under subsection 1 is relevant for defense purposes, it may at any time before grant of a patent notify the controller to that effect, and thereupon the provisions of subsection shall apply as if the invention were one of the class notified by the central government, and accordingly the controller shall give notice to the central government of the directions issued by him. Now, what happens in cases where the controller does not pick up an invention as being relevant for defense purposes? There could be many reasons why the controller does not pick it up. One, by oversight the controller and the patent office could have missed it. Two, the list of notified things may not have this technology mentioned in it. So, there could be many reasons why the controller may think that something is not relevant for defense purposes. So, in such cases, if the central government forms an opinion that an invention is in respect of which the controller has not given any direction is relevant, at any time before the grant, it can notify the controller to that effect, saying that this is relevant, and thereupon the provisions of the subsection shall apply as if the invention were one of the class notified by the central government. Now, once the central government communicates to the controller that this technology, though it is not notified, is relevant for defense purposes, then it will be as if it was a class notified by the central government. So, the fact that the central government has communicated to the controller that a particular technology is relevant is enough. It is as though it issued a notification saying that this is a class that is notified. And once that happens, the controller shall give notice to the central government of the directions issued by him. Again, the right to issue a secrecy direction is only with the controller. You can see that the central government will remind him that this technology is also relevant, but still the direction has to be issued by the controller. The reason for this is an invention which is covered by a patent, when it is filed before the patent office, it is the controller who has a control over how the information is kept a secret or how it is to be published. This is not something which is the central government does have many powers. Central government even has the power to revoke, central government has the power to make rules, and you can say that the controller is authority under the central government. But the central government in itself cannot pass this direction because the act gives the controller to pass the direction. So, even when the central government informs the controller this particular technology is relevant for defense purposes, it has the effect of a notification, as it is as though the central government has notified this particular class also, and based on the notification the controller will have to issue special secrecy directions. So, that is again it has to be done by the controller. So, the controller will issue secrecy directions once the government informs the controller that something is relevant for defense purposes, though it may not have been in the class notified. We understand that there is a class of inventions and technologies notified by the central government. This particular technology was not there in it, but still when the central government communicates to the controller shall issue notice of the directions. So, he will have to issue directions and inform the central government. Now, what happens to the secrecy directions which have been issued by the controller? 36. Secrecy directions to be periodically reviewed. The question whether the invention in respect of which directions have been given under section 35 continues to be relevant for defense purposes shall be reconsidered by the government at intervals of 6 months or on a request made by the applicant which is found to be reasonable by the controller, and if on such consideration it appears to the central government that the publication of the invention would no longer be prejudicial to the defense of India, or in the case of an application filed by a foreign applicant it is found that the invention is published outside India, it shall forthwith give notice to the controller to revoke the direction, and the controller shall thereupon revoke the directions previously issued given by him. And 2. The result of every reconsideration under section 1 shall be communicated to the applicant within such time in such manner as may be prescribed. We will have to look into the rules for that. So, what happens when a secrecy direction is issued by the controller? The controller issues a secrecy direction, and we have already seen that though the controller issues the secrecy direction, he only controls the transmission of information. He only protects the publication of information. He does not take a call on whether a particular technology is relevant for defense purposes, because that is beyond the purview of the functions of a controller. So, we know that it is the central government which would take a call on whether a particular technology is relevant for defense purposes. Now, once the central government takes the call, section 36 allows the central government to reconsider its decision every 6 months, because in 6 months so many things could have happened. The technology would have come into the market, or this technology could have been published in a journal, or some information about it could have come out from a third party, need not be through the applicant. So, if the information is already out, then there is no wisdom in keeping or maintaining the secrecy direction. In such cases, the central government will ask the controller to revoke it. Central government does not revoke it. Central government will now say that this technology for which we passed a secrecy direction is now available for everyone, it is no longer a secret. So, revoke the secrecy direction. So, the only way you can request, or the central government or the controller can revoke a secrecy direction, is the invention ceases to be a secret. So, if you are asked what are the conditions under which a secrecy direction issued by the controller can be revoked, the fundamental condition is that what was earlier kept a secret is now no longer a secret. It is not a secret in India, or it was disclosed outside. There could be n number of reasons. You need not have disclosed it to the world, third party could have disclosed it and it is now in the public domain. The fact that the invention is in the public domain is enough to revoke a secrecy direction. Now, so this the central government will have to review every 6 months, because there will be new disclosures coming, new technologies, new products coming. The central government will have to reconsider it every 6 months to see whether the secrecy directions that have been issued are valid. Alternatively, the applicant can make a request. Now, when the applicant makes a request to the controller and the controller finds that request to be reasonable, and if on the consideration the central government reconsiders it and feels that it need not be kept a secret, then it will ask the controller to revoke the direction. So, either the central government can do on its own every 6 months, or the applicant can ask the controller to reconsider it. There are two ways to revoke a secrecy direction. Now, if the central government comes to a conclusion that the invention would no longer be prejudicial to the defense of India, could be that the technology has changed or something else has happened which is much more relevant, the central government can say that revoke the secrecy direction. The other case is that if the application filed by a foreign applicant is found, it is found that the invention is published outside India, then again the controller shall be asked to revoke the direction. Now, if there is an defense related technology filed by a foreign applicant in India, most likely the foreign applicant would have filed applications in his home country. Now, if those applications get published, assume that those country did not grant a secrecy direction, then there is no point in keeping a secrecy direction on the Indian application, because it is already published, same application. So, the corresponding foreign application got published, so there is no point. So, if a publication happens and if the secret is no longer a secret, that is a ground for revoking the direction. So, you revoke a secrecy direction if a secret does not remain a secret, or if the central government is of the opinion that the technology or the invention covered is no longer relevant or no longer prejudicial to the defense of India. So, these are the two conditions. Now, once the central government reconsiders, it shall be the decision shall be communicated to the applicant. Now, let us look at the consequences of a secrecy direction. What happens when a secrecy direction is issued? Now, when a secrecy direction is issued by the controller shall not pass an order refusing to grant the same. He cannot refuse the application while an order is pending. So, as long as there is a secrecy direction in force, the application cannot be refused, and no appeal shall lie from any order of the controller passed in respect thereof. Now, if the controller passes an secrecy direction, then there cannot be an appeal in respect of such a direction as long as the secrecy direction is in force. Now, we had already mentioned the provisions of appeal are contained in section 117A of the Patents Act. Instances where an appeal lies to the Intellectual Property Appellate Board. So, 35, 36, 37 which we have been seeing, an order issued by the controller cannot be appealed. They are not grounds on which an appeal can be filed before the Intellectual Property Appellate Board. So, the subsection continues, provided that the application may subject to directions proceed up to the stage of a grant of a patent, but the application and specification found to be in order for grant of the patent shall not be published, and no patent shall be granted in pursuance of that application. So, even if there is a secrecy direction, the patent office can continue the process of prosecution and it can make it ready up until the grant of a patent, but it cannot grant the patent. So, everything else short of grant can happen, everything else short of reject can also happen. So, this secrecy provision affects the outside world. The prosecution of the patent is not stopped by a secrecy provision. So, if there is an FER issued, the applicant can respond to the FER. If there are further objections issued by the patent office, the applicant can do that, respond to them. If the patent office insists on an amendment, the applicant can amend the patent. They can do any number of things, but for either grant of the patent or reject of the patent. These two things cannot happen. The patent office cannot grant or reject. Short of that, they can do everything else. So, and we are talking about internal procedures within the patent office. 37(2), where a complete specification filed in pursuance of an application for a patent for an invention in respect of which directions have been given under section 35 is found to be in order for a grant during the continuation in force of the directions, then if during the continuation in force of the directions any use of the invention is made by or on behalf or to the order of the government under sections 100, 101 and 103 shall apply in relation to that use as if the patent had been granted for that invention. And if it appears to the central government that the applicant for the patent has suffered hardship by reason of the continuation of in force of the directions, the central government may make to him such payment, if any, by way of a solatium as appears to the central government to be reasonable, having regard to the novelty and utility of the invention and the purpose for which it is designed, and to any other relevant circumstances. Now, this subsection tells us if a secrecy direction is given under section 35 and the patent is found to be in order for a grant. So, it has got over all the objections in prosecution and it is found to be in order for a grant. If during the continuation of the secrecy direction there is use of the invention by the government, and we know that the government can use or even acquire the invention, like how the government can acquire private property. The Land Acquisition Act allows the government to acquire private property. The government can also acquire intellectual property or use intellectual property, and the provisions from section 100, 101 and 103 pertain to that. Now, if the government uses the invention, then it will be as though it used it under section 100, 101 and 103 as if the patent has been granted. Now, when we come to section 101, 100, 101 and 103, the government, if it uses a patent after the grant, then the government can give some compensation in lieu of the use. There are provisions for that. Or if the government acquires the patent, then the government can give some compensation. Now, 100, 101, 103 all pertain to applications that have already been materialized into a grant. Section 100 onwards applies to cases where there is already a grant and government wants to use that invention. When the government uses that invention, it gives royalty or some kind of a compensation. Now, in this case, when a secrecy direction is issued, we had already seen that there cannot be a grant, because pending secrecy direction, the patent cannot be granted. So, when there is a secrecy direction and the patent cannot be granted, but the government wants to use it or the government uses that invention, then it will be as if the provisions of 100 apply, which means it will be treated as though this patent has been granted. So, this is a deeming provision. You can see the word as if the patent has been granted, which means the patentee, or which means the applicant will have the rights of a patentee even before the grant. So, this is a deeming provision which allows the applicant to have certain rights of a patentee even before the grant. The reason being, the grant, the only issue that hinders a grant is the secrecy direction. Had there not been a secrecy direction, it would have been granted. And because the government is using it, the government will now regard this as a proceeding under 100, 101 and 103. There could be a question. What are the instances in which the government can deal with an application, deal with an invention in the application state and grant compensation to the applicant for government use when a patent has not been granted? When a patent has been granted, section 100 onwards will apply, but when a patent has not been granted, if there is a secrecy direction, then section 37 will apply. Now 2b tells us that if it appears to the central government that the applicant has suffered hardship by reason of continuation of the directions, the central government may pay him a solatium considering the novelty and utility of the invention and for the purpose for which it was designed and for other relevant circumstances. So, if the person suffers hardship, the applicant suffers hardship due to the continuation of the direction, the central government can give some compensation, solatium. So, some payment can be made. 3. Where a patent is granted in pursuance of an application in respect of which directions have been issued under section 35, no renewal fee shall be payable in respect of any period during which those directions were in force. So, there could be a question that what are the instances in which an applicant or a patentee whose patent has been granted is not bound to pay a renewal fee during the life of a patent. The renewal fee is collected after the grant, because if the patent office is going to reject, the patent term starts from the date of filing the application. The 20-year period starts from the date of filing the application, but on the date you file the application, you are not going to start paying the renewal fee. The renewal fee is something that you are expected to pay only if your application materializes into a grant, and the renewal fee is always collected by asking the applicant to pay the backlog. So, if you get a grant in the 5th year, you will be asked to pay the renewal fee from 1st year onwards, correct? Because it's always like that. The renewal fee cannot be paid at the time of application because you don't know whether you will get a grant or not. So, inevitably in all the cases the renewal fee is backdated, or you pay it upon grant, you pay it for all the years you have been those years, though the application was still in a state in which it was not a formal grant, but still your term covers the time you spent in the application state. So, if you spent 5 years in the application state in the patent office, still you will have to pay the fees for all those 5 years after the grant. The only condition where you need not pay those fees is if there was a secrecy direction. If there was a secrecy direction, you need not pay the renewal fees as long as the secrecy directions continue. 38. Revocation of secrecy direction and extension of time. When any direction given under section 35 is revoked by the controller, then notwithstanding any provision of this act specifying the time within which any step should be taken or any act done in connection with the application for a patent, the controller may, subject to such conditions if any, as he thinks fit to impose, extend the time for doing anything required or authorized to be done by or under this act in connection with the application, whether or not the time has previously expired. When a secrecy direction is issued, there are certain things an applicant cannot do. The applicant cannot take a request for expedited examination. Even if he is entitled to it, he cannot do that, because if there is a requirement that the application has to be published, that requirement is not going to be satisfied now. The applicant may not be able to contest a pre-grant opposition, because that will involve giving notice to third parties. Third parties will get to know if any amendment is carried during the pre-grant opposition. So, there are certain things, and because of the secrecy direction the applicant may not be able to do certain acts. So, when a secrecy direction is revoked by the controller may extend the time for doing anything required or authorized to be done under the act. This provision allows the controller to extend the time for doing something because there was a secrecy direction in force. Secrecy direction can tie down an applicant's ability to prosecute the application, and we know that in patent law there are various timelines which an applicant has to conform. But once a secrecy direction is revoked, the controller can extend the time for doing those things. It could be anything. So, the controller has the power to extend the time beyond the secrecy direction, and we had already seen it in Rule 24B. The 48-month period for taking a request for examination, within which time you have to take the request for examination, will consider if there is a secrecy direction pending, then it will be 6 months from the expiry of the secrecy direction. So, wherever a secrecy direction is there, once it expires, the controller can give further time for doing things. Now, let us quickly have a look at Rule 72. Rule 72, communication of result of reconsideration under section 36(2). We had seen that under 36(2), the central government shall reconsider the secrecy directions issued by the controller in intervals of 6 months, or if the applicant approaches the controller as and when the applicant approaches. Now, 72(1) states that the result of every reconsideration under subsection 1 of 36 shall be communicated to the applicant for patent within 15 days of the receipt of the notice by the controller. So, if the controller receives notice from the central government after reconsideration, it shall be communicated to the applicant within 15 days. 2 states that extension of time on revocation of secrecy direction under section 38. Now, this actually covers section 38. Now 72 mentions 36(2), 72(2) refers to section 38, which is revocation of secrecy direction and extension of time. The extension of time to be given for doing anything required or authorized to be done under section 38 shall not exceed the period for which the directions given by the central government under section 35(1) were in force. Now, if the secrecy directions were in force for say 12 months, now the extension of time for doing anything under the act under section 38 shall not exceed 12 months. So, this only gives the applicant a time equivalent to the time where he could not do anything. If the secrecy direction was for 12 months, he was not able to do things for 12 months, he will be given an extension of another 12 months to do whatever he wants to. If the secrecy direction was only for 6 months, then the extension of time should also be only for 6 months. So, this provision just says that the extension of time will not exceed the period of for which the directions were issued and were in force. Now, let us look at section 39. Section 39 is slightly different in its operation, because all this while 36, 37, 35, 36, 37, 38 were specific cases where there was an invention, an application for which was filed before the patent office, and the controller felt that this could be relevant for defense purposes, and he issued a secrecy direction. Once the direction is issued, the central government will have to look at it, either uphold the secrecy direction or ask it to be revoked, and the central government also has the power to intimate the controller separately whether the controller looks at the class of notified inventions and technologies. Whether he does that or not, the controller, the central government has the power to initiate things on its own. 39 pertains to application for patents outside India. 39, residents not to apply for patents outside India without prior permission. Now 39 only affects people who are resident in India. 39(1) states, no person resident in India shall, except under authority of a written permit sought in a manner prescribed and granted by or on behalf of the controller, make or cause to be made an application outside India for the grant of a patent for an invention. So, a person who is resident in India cannot make an application outside India for the invention that was made in India without a written permission of the controller, unless A, the application for a patent of the same invention has been made in India not less than 6 weeks before the application outside India. So, you need not seek permission, you need not seek the permit if you had made the application first in India, then there is no need for seeking permission. If an application was made not less than 6 weeks before the application outside India. So, 6 weeks before the foreign application was made, that is the application outside India, an application was made in India, which means you file first in India. If a resident files first in India, there is no need for him to take a permission under section 39. And either no direction has been given under subsection 1 of 35 in relation to the application in India, or all such directions have been revoked. Now, this brings an interesting aspect into how the patent office works. Now, one, we say that if a person who is resident in India has to file an application for a patent, he has to file it in India first. If he wants to file first outside India, he needs to take a permission. So, in an ideal case, he will file the application in India. After 6 weeks, he will file it in any foreign country where he wants. But if an application is not filed in India, then he will have to take a permission. Now, the permission is not required if no direction is passed under section 35(1), or if a direction was passed and it was revoked. To simplify this, let us first look at the instances where a person resident in India need not take a permission. Let us look at then we will look at the instances where he needs to take permission. He need not take permission if he makes the application first in India, and after 6 weeks he files an application outside India, no permission required. And he files an application in India and there is no direction issued under 35(1), no secrecy direction issued, or secrecy direction was issued and it was revoked. Now, this tells us that there is a 6-week window period which you have to wait for filing a foreign application. If you file an application in India and if you want to file a foreign application, you will have to wait for 6 weeks, and we can assume within that 6 weeks the controller will quickly look into the application and see whether it is relevant for defense purposes, and he may issue an secrecy direction under section 35. So, the 6-week window period is allowed for the controller to look into the application and see whether it is relevant for defense purposes, because within that 6 weeks, if he passes a secrecy direction, then you cannot file an application outside India, because the condition for filing an application outside India is, one, you should file it in India first and wait for 6 weeks to file it outside India, and no secrecy direction should be passed. If you have invented something in India and if you are a resident, then in a normal case, if you want to file an application outside India, you will wait for 6 weeks and then file the application. Now, if you want to file first in a foreign country, then you will need to take the foreign filing license or the permit. The act says written permit. You have to seek a written permit from the controller. There is a form for it. You can see the cross reference. Form 25 is the relevant form. 39(2) states that a controller shall dispose of every such application within such period as may be prescribed. An application that has been made seeking a written permit shall be disposed of as prescribed, provided that if an invention is relevant for defense purpose or atomic energy, the controller shall not grant permit without the prior consent of the central government. So, apart from defense, now we also have atomic energy coming in, but from section 4 we know that a patent covering atomic energy under section 20 of the Atomic Energy Act shall not be granted. 39(3) states that this section shall not apply in relation to an invention for which an application for protection has been filed in a country outside India by a person resident outside India. So, this will not apply for non-residents. If a person is not a resident in India, then he can file it without seeking the permission in the country where he wants to, most likely the country where he is a resident. So, from this we understand that there are, if a resident has to file an application first in a foreign country, he has to seek permission. But if he wants to file in India and then file in a foreign country, the permission is not required. He just needs to wait for 6 weeks and then file it, provided there is no secrecy direction. If there is an application pending before him for under form 25, that is a foreign filing license, seeking a written permit, the controller shall see whether the invention is relevant for defense and atomic purposes. So, normally if you see section 34, delete last few words. Normally if you look at section 35, 36, 37, 38, it only talks about defense purpose, but 39 introduces atomic energy. We did not see the word atomic energy in the other section, but 39 introduces atomic energy. And a person who is resident outside India, he is not bound by this provision, he can directly file an application outside India. Now 71 is the relevant rule for this section. Permission for making patent application outside India under section 39. 71(1) the request for permission shall be made in form 25. 2. The controller shall dispose of the request made under 71(1) within a period of 21 days from the date of filing of such request. So, in roughly 3 weeks he has to dispose of the request, provided that in case of inventions relating to defense or atomic energy, the period of 21 days shall be counted from the date of receipt of the consent from the central government. So, the central government, as I already told you, if an invention pertains to defense purpose, the decision is taken by the central government. The controller may pass a secrecy direction, but he is not the deciding authority, because he is not expected to know what is the current technology used in defense. So, the decision is taken by the central government. So, the period of 21 days, if it pertains to atomic energy and defense, will be started or will be counted from the date of receipt of the consent of the central government. So, when the central government indicates its consent, the 21 days will start from that day. Section 40 talks about certain liability provisions. There are certain consequences for contravening or for not complying with section 35 and or section 39. Without prejudice to the provisions contained in chapter 20, if in respect of an application for a patent, any person contravenes any direction as to secrecy given by the controller, which means the controller gives a secrecy direction and the person does not comply with it under section 35, or makes or causes to be made an application for the grant of a patent outside India in contravention to section 39, which means being a resident without seeking permission, he filed a foreign application first. So, that is a contravention of section 39. The application for a patent under this act shall be deemed to have been abandoned, and the patent granted, if any, shall be liable to be revoked under section 64. So, if a patent is pending, it will be deemed to have been abandoned. Yet another provision where the deemed to have been abandoned figures. So, this is yet another provision where deemed to have been abandoned figures. So, or if a patent has been granted, it is liable to be revoked, which means this becomes a ground for revocation, and you will find that the ground for revocation is in section 64 1n. Section 64 1n states that the applicant contravened any direction or secrecy passed under section 35 or made or caused to be made an application for the grant of a patent outside India in contravention of section 39. The same language is reproduced in 64 1n. So, it is liable to be revoked means it can be a ground by which it can be revoked, but some person has to file an application or a application for revocation or raise a counterclaim before the High Court. So, it becomes a ground, whereas if there is contravention at the application stage, then it will be deemed to have been abandoned. Section 41, finality of orders of controller and central government. All orders of the controller giving directions as to secrecy as well as all orders of the central government under the chapter shall be final and shall not be called into question in any court on any ground whatsoever. We already saw that orders passed under secrecy provision cannot be appealed. We saw that before the IPB. Here they cannot be agitated or they cannot be called to question in any court. So, on any ground whatsoever. So, a secrecy direction, because it pertains to national security, to the defense of the country, you cannot agitate as to why a secrecy direction was passed before the Intellectual Property Appellate Board, which is an appeal, and you cannot even go to the normal courts by way of a writ petition or by way of a review. You cannot go to the normal courts to say that this has judicial review, that this provision affects me. So, there is a comprehensive bar in approaching the courts or in filing appeals. 42. Saving respecting disclosure of government. Nothing in this act shall be held to prevent the disclosure by the controller of information concerning an application for a patent or a specification filed in pursuance thereof to the central government for the purpose of the application or specification being examined for considering whether an order under this chapter would be made or whether an order so made should be revoked. Now, there is a provision under the Act which states that the central government will be bound by a grant of a patent. Section 156 tells us that patent to bind government. Subject to other provisions contained in this Act, the patent shall have all intents the like effect as against government as it has against any person. Now, because a patent binds the government and because it is the government which grants the patent, there could be an issue with regard to disclosing the controller disclosing certain aspects of the invention to the central government. How can you disclose this? Because the central government has the power to acquire an invention under section 100, 101 and 103. They have the power to use and acquire. So, will this fall foul of some provision if the controller communicates information with regard to an invention to the central government and the central government quickly issues a secrecy direction and the central government starts using it. So, this may look like an arbitrary provision that the controller informs the central government and the central government issues a secrecy direction and starts using it, because the Act provides for all these things. So, but the saving provision says that nothing in this Act shall be held to prevent a disclosure. So, just because we have certain secrecy measures, delete last sentence, just because we have certain protection for the applicant, it does not prevent the controller from making certain disclosures to the central government, because the defense of the country is involved. Normally, the controller does not make a disclosure to the central government, because the patent office keeps the prosecution as a affair between the applicant and the patent office. Normally it is not disclosed, third parties are not allowed. But in this case alone, there is a power to make a disclosure to the central government, and that cannot violate any other part of the act. And this is being done for the central government to examine and consider whether an order issued has to be revoked or whether an order issued can be sustained.